Please court.
Yes, please proceed.
I'm Rich Caskey. I'm here on behalf of the appellants Catherine Wolfram and Tricia Wolfram. I'd like to reserve 5 minutes of my time for rebuttal if I may.
You got it. Thank you.
So to sum it up in a nutshell, the real issue for this court in simple terms is whether the probate court was in error to appoint a personal representative nominated in the decedent's will as a successor without an evidentiary hearing. This was done on summary judgment and with record
Was
evidence.
there evidentiary hearing requested at summary judgment itself? Did we want a hearing on this?
I don't believe there was, Your Honor. This
Okay,
was an adversary.
So you normally don't get an evidentiary hearing on a summary judgment unless somebody says we need it, they explain their reasoning, and then the judge says, okay, let's have a hearing. Then you might as well just have a trial, right?
Well, this is heading for trial, and that's exactly what we're requesting, that it be remanded for trial. This was an adversary proceeding within the probate estate,
Right.
and it was declared adversary. And once any petition, any motion is declared
But the rules of
adversary.
civil procedure are invoked by declaring an adversary. They don't require an evidentiary hearing on a summary judgment. The whole point is to avoid a hearing.
Yes, but the underlying issue is the appointment of the personal
You've got
representative.
two underlying issues. One is the legal issue. You have to give preference by statute to the named PR in the will, which happens to be the son. And then that person has to be qualified, and that's a judgment call. So you've got de
Yes,
novo and abuse of discretion.
yes.
So you're really arguing abuse of discretion by not having an evidentiary hearing, or abuse of discretion in appointing someone that inarguably has a lot of baggage.
No, Your Honor, I'm saying that this is no different than any civil proceeding once it's been declared adversary. The petition for administration that was filed by counsel below to appoint Frank Jr. as the successor PR was declared adversary. That means it follows just like any civil trial. It has to be an issue. You get discovery, you get to take depositions, you can move for summary judgment. That's what invokes the ability to move for summary judgment. It does not mean you have to ask separately for an evidentiary hearing. In fact, simply by declaring an adversary means that you're on the track to go to trial. And eventually,
What
if the
case are you
notice
citing
is
for
an
that
issue.
proposition?
I'm sorry.
What case are you citing for the proposition that the court has a duty to set an evidentiary hearing on a summary judgment?
It's not that the court has a duty to set a hearing on the summary judgment. It's that the underlying petition becomes its own pleading. And then it's governed by the rules of civil procedure, which carry it all the way to conclusion.
I get all that. I did probate for a long time. I was a trial judge.
Yes, Your Honor.
And I'm familiar with the adversary procedure.
Yes.
All right, keep going.
So that's the procedural issue. And I think that's one of the things that's neat about this case is you've got the probate issue of the discretion the court has in appointing a personal representative. And then we've got this new summary judgment standard. And of course, none of the cases that we have are summary judgment cases, and necessarily that means none of them are governed by or decided under the new standard. But I think the place to start is Pontrello. And in all the litigation that we do as probate litigators, and counsel and I are both probate litigators by nature, you always argue Pontrello. That's the law in this district. And Pontrello giveth and it taketh away for both sides. Pontrello says exactly what you said, Judge, that there's a very limited discretion. Normally you give deference to the person nominated under the will as the personal representative. But it says there are exceptional circumstances that can arise that allow the court to exercise discretion to appoint someone else. Pontrello identifies two instances where exception arises. And I think record evidence was put in by counsel below on our side of the table to meet both of those things. One is unanticipated facts and circumstances in the context where the testator did not have an opportunity to change the will. That's one category. Another one, and I call that the unanticipated facts and circumstances prong. The other prong is the suitability of the
Well, when you
person.
file a motion to contest the accounting, of course, the intestate didn't know that because she's passed away. So that's you need more than that.
And this set of facts is exceptional. It's unique. And it's worth 90 seconds to just hit the highlights without attacking the specific.
But the unforeseen circumstances, I think there's one case, it's like where the wife was planning the murder.
The
I mean,
wife planning the
that
murder.
seems kind of obvious.
It is, and there's no case that says that's the only unforeseen circumstance, right? Pontrello says unforeseen circumstances in the context where the testator didn't have an opportunity to change the
But
nomination of the will.
isn't this something that simply, because the statutes talk about it, here we have the Mr. Holcomb, who is qualified. Preference is because he's designated to be the successor. And then there's a statute that allows someone to challenge that once they're appointed, correct? So isn't this something for a later day?
No, that would be the removal statute. And I think Pontrello is clear that you don't use grounds for removal to challenge the initial appointment. So you've got the preference and appointment and the qualification set of statutes, and then you have a separate set of statutes that are grounds for removal. This isn't a removal case. This falls under Pontrello in the exceptional and unexpected circumstances. This decedent died over a decade ago, 2010. His first nominated PR was his wife, and she was appointed, and she served for a year and a half, 2 years, and administered the estate and was discharged, and the estate was closed. All of the record, facts, and circumstances that counsel below put into the record for summary judgment purposes occurred over the next decade. And it was the litigation of family and all those things I don't want to belabor. But clearly the testator wasn't around to change his will. And so it's not that he had an old will and never got back to his lawyer to change the designation of PR. It's that he died. His preferred PR, his spouse, was appointed. And then 10 years went by. She got reappointed to reopen the estate and do some administrative stuff. And of course, Frank Jr. challenged some of that, but then she died. And then he says, wait, I'm the second nominated PR, and he's coming in. Those are the facts and circumstances that counsel below put into the record. And of course, the testator could not have anticipated all the fighting, all the allegations, all the judgments, all the things that happened over the next decade, because he was dead and he couldn't change his will. So that's, and by the way, that's not a point. That side of the Pontrello analysis is not a point that the judge below referenced in his order. The order below states that there was not sufficient evidence to show that Frank Jr. didn't have the character. It went to the suitability part of Pontrello and what the other cases talk about. So and then you've got the issue, this was summary judgment. It was headed to trial otherwise. And again, as our request would be that the court remand it back down for the final trial for the evidentiary hearing to reverse the remand. But you've got evidence in the record of this unique set of circumstances. I would say exceptional. I've certainly never seen it. This decade passage of time and a record filled with things that happened that I think a reasonable jury and a person as a juror reasonable trier of fact could conclude otherwise if it went to a trier of fact. And I think that's the summary judgment standard that we're under. Because essentially what the court ruled here was, as a matter of law, I've got to appoint this successor nominated PR. And I want to go back to this point that the judge made below in the order that the judge found there was not sufficient evidence to refute his character. I want to make 2 comments on that. One, I think under summary judgment, under any standard, character, credibility, those sorts of things are not governed at the summary judgment level. That's why we have a trial. That's part of the reason the clients that I have now are appealing these. They never got to be heard by the trial court. They never got, the probate judge never got to hear the testimony or see the actual nominated personal representative be cross-examined on these issues. In Pontrello.
Let me ask you a question. I mean, you got an experienced trial judge who's been around. He figures, I'm stuck by the statute. This guy's not as bad as they claim he is, but even if he's thinking in the back of his mind, I can get rid of him down the road if he screws up. Isn't there a petition to remove a PR? Is there a way to remove a PR by petition for malfeasance?
Yes, absolutely.
In the future.
Absolutely, and that's what Justice Smith was discussing. There's a removal statute, and Judge Williams below stated in his order, I fully hope and expect that this PR will administer the estate prudently, but if not, you can always come back and remove it. But the issue is, we never got to the trier of fact on the issue of appointment. And I think the elements, the boxes were checked on Pontrello under this unanticipated circumstances test to at least get you to the trier of fact. And it is discretionary, but there's no case that says as a matter of law, you must appoint the person nominated in the will.
But the judge didn't make the ruling on that belief.
The judge didn't.
The judge knew he had discretion not to pick this guy, and decided, well, there's not enough here for me to go that route.
Yes, and I get the practical implication of that, and as counsel points out, this is a bench trial. But I think that invokes another really interesting issue under the new summary judgment standard. I don't think the court can exercise discretion when there's uncontroverted record evidence that raises the issue, that gives it to that moves it into that category of exercising discretion, where you have to weigh character and you have to weigh credibility. I don't think that can be resolved at the summary judgment level. I think you're allowed to get to trial on that. And I think in this case, again, the elements were checked such that this puts this case with these facts in front of a trier of fact to make that determination. And I actually think, looking at it, that this is a good judge. This is a judge who's independent and thoughtful and mindful. I think at a trial with full evidence and where he can hear testimony and hear from Kathy and Patty and hear from Frank Jr. and listen to them, I think it changes the outcome of this. But the underlying question, I think,
Is there
goes
not an
to-
opportunity to do that in submitting any depots or affidavits? I mean, it was a summary
we
judgment.
never got to depositions. There were affidavits. The affidavit from Frank Jr. said, I'm nominated. The affidavit and the judicial notices that counsel below filed for Kathy and Patty went to character, fitness, and suitability, and this fact
So they were
pattern.
heard, so they were heard
Well,
on summary judgment.
the testimony wasn't, it wasn't not as to his character and credibility.
But
What was-
didn't they have an opportunity to state whatever they wanted to state in the affidavits?
In the affidavits, they did, but the affidavits were largely about this first test, right? The unanticipated circumstances and all the things that occurred during this decade-long period after the testator died. So the response I was giving before was a practical one, which is it's a bench trial. The judge is going to exercise discretion. Didn't he just do it? And I think maybe yeah, but you can't exercise discretion at the summary judgment.
Okay, so are you arguing that there were disputed issues of material? You're not.
I'm not. In fact, the evidence that was put in by counsel below for Kathy and Patty was unrebutted. And so I actually think summary judgment could have been granted that way because it was unrebutted. And the reason this is important, and we've got a lot of case law that's been cited in both briefs. Some of it deals with preference and appointment when you don't have a person nominated in a will, right? You don't always have a nominated person, and that's given a higher level. In order for the judge to exercise discretion when a PR is nominated in a will, it has to be one of these two things under control to get you to the exceptional circumstances. But there are other cases that talk about the judge exercising discretion in preference, right? If you have an intestate estate.
Well, that's where the judge, where they're court appointed.
Well, they're in all instances, it's court appointed.
Well, but they're not designated in a will, and you're not
Correct.
deferring to the wishes of the deceased.
Correct, but it's still in the discretion of the court, and there's an order of preference. And so the court applies a preference and an order of preference according to the statutes, but it's still discretionary. And so if we're answering the question, and if this court's going to answer the question about whether the court can exercise discretion at the summary judgment level, there are other things in probate that are discretionary, like the appointment of a PR when you're deciding order of preference, or if you have two people and there's no preference. They have the same equal preference. If you have an intestate estate and you have two children, they have the same preference. You could have uncontroverted evidence for both of them. This person is an accountant. He's knowledgeable about business affairs. He had close connections with the decedent's business dealings, uncontroverted. This person puts an affidavit in and says, this person's a lawyer, a probate lawyer. They know how to administer estates. They have good character, uncontroverted. What does the judge do? It exercises discretion, or to appoint one of them, both of them, or someone independent. But that gets you past summary judgment. If the trier of fact can conclude one way or the other, I think that gets you past summary judgment. In order to grant summary judgment, the court had to have found as a matter of law that Frank Jr. must be appointed. There's no other way around it. Even the new summary
The judge didn't say that.
did not.
The order of summary judgment hints that he considered more than just the statute.
Yes,
I mean, I can't accept that argument unless there's a motion for hearing. The judge unequivocally said, I do not have discretion. I don't think, he didn't say that.
yeah, I don't, you can't tell from the way the order is written. The judge didn't say I'm exercising my discretion here. But the summary judgment standard
But
is still
no,
as a matter of law.
it's a very interesting argument, but that's why they make a motion for rehearing under the contested rules of civil procedure. You file a motion for rehearing and say, hey, Judge, what did you really mean? He elaborates, or he says on the record, there's something, I'm assuming that wasn't done because you don't have an amended order or a motion on the rehearing, an order on the rehearing motion.
And I thought there had been a request for a rehearing, and I don't know, you know, when
I don't know
you-
what happened, didn't help you, obviously.
Right, and when you argue, when you make the oral argument, you didn't write the brief, I was told you didn't build this plan, but you got to fly at council, and
Well, they're
that's
gonna
what I.
change all that now. They're about to change the rules, so be careful. In the future, if you have a disputed issue of fact that the judge didn't cover, in order to raise it on appeal, they're gonna make you file a motion for rehearing to to pin the judge down. So they're about to change a few things. That's in the works. So I digress. I won't charge you the extra time. You're at your 5 minutes if you stop now.
I would like to reserve it, but I'm happy to answer.
No, I'm gonna save you the 5 minutes. You're actually at 3.4.
Okay.
But I asked you a question at the end. I shouldn't have done that.
I'll take it, thank you.
All right.
Please support.
Yes.
My name is Barry Spivey. I represent Frank Holcomb Jr., the personal representative. I'm here mostly, I think, to answer questions, but I would say that I agree that Fontrella case out of this court is the leading case in this area.
Well, how about we start with his contention that the wrong standard was applied? We don't have the standard on motion for summary judgment that the judge considered appropriately.
Well, I think, this is unusual, and I made the point in the brief in that, when you get to the Supreme Court, the U.S. Supreme Court, Anderson v. Liberty Lobby, they say the inquiry involved implicates the substantive evidentiary standard of proof. Well, when you have a discretionary decision by the court, a very limited discretion, there is no standard of proof. But I cited the Canacaris case and what the court has defined judicial discretion to be, and it.
I was decided before the summary judgment was amended.
Oh, well,
A long time ago.
well, this took place after the amendment, Your Honor. So we're working under the new rule here, which is new for most of us, I think, or many of us. But it's hard to say when a judge is sitting there, he's asking himself in this case, under the Fontrella case, I've got very limited discretion to deny appointment of this nominated personal representative. Okay, are there exceptional circumstances other than the usual in all the cases? Not all the cases, but there are a number of cases throughout Florida in all the districts that talk about dissension among beneficiaries or disagreement between the appointed PR and
Well, this is a non-evidentiary hearing.
right.
So all these other things must have been argument of counsel.
Well, yes, but what they filed, the court looks at the evidence filed in support of summary judgment. Both sides file motions for summary judgment. And the court says, okay, if this is all I've got at a plenary hearing, then they still lose because it's not enough. It just shows they don't like their brother and they're willing to fling any mud they can find against the wall. So it is not evidence. The evidence they filed was complaints in New Jersey litigation filed by who knows who. They're just allegations. There's no proof. There was no.
Well, weren't there allegations that he filed objections to the accounting?
Of course he did. I did that on his behalf.
Okay.
The
And
objection
isn't that one
was
of the-
that,
Isn't that one of their complaints as well, that he's put himself in an adverse interest to the estate?
well, they've been saying that all along, but any personal representative should have that obligation. to recover almost $1 million of principal cash out of the estate that she had no right to take out. And this was unknown to him, of course, because during the time from 2012, when she closed the estate administration until she reopened it in 2020, there were no accountings. He had no information whatsoever about what was going on. He didn't know this until the accounting was filed. She filed a first and final accounting in 2021.
Well, does the waiver of accounting he filed in the first estate carry over into the new probate?
They've been arguing it does, but I don't see how it can, Your Honor. What, I mean, how can you get a waiver and then file an accounting that shows you've taken?
It's not a
$1 million?
waiver in perpetuity, you're saying? It's not a waiver in perpetuity.
Of course not, it can be to a subsequently filed accounting. But the accounting disclosed a number of irregularities. That wasn't the only one, but you know, that they made a big deal about how he was going to be such a disaster as personal representative. He's done nothing.
Well, I mean, I think we're not here on a summary judgment. We're here on an order appointing a PR, correct?
Correct.
So he's trying to apply the summary judgment standard to the order appointing PR, where the judge basically said, I don't have any proof, he's not qualified, therefore he must be qualified, but I'm not applying the summary judgment standard. So is that even that relevant to a case that's being appealed for an abuse of discretion on an appointment of a PR?
Well, it is debatable, Your Honor. I mean, I've had a difficult time with it because if there had been no summary judgment motions and this same evidence was presented and he made the decision, it would just be here purely on a matter of abuse of discretion. And I think that's really what it's about. The summary
judgment was kind of unnecessary. You both, did both sides file a summary judgment?
Well, it was, yes, both sides did.
So the judge granted.
His motion.
I don't think I have the order anymore. Well, the judge granted your summary judgment,
Yes.
but the judge could have just denied his and be done with it. You didn't have, it doesn't seem like this is a summary judgment type case. It seems like it's more,
Yeah.
the judge appoints the PR and you appealed the appointment.
Well, they did appeal the appointment. That's really what we're here on, and that's what the appeal on is the appointment of him as personal representative.
But by way of a summary judgment.
Correct.
Okay.
And,
I got you.
So anyway, I had to do a little bit of educating in the federal case law on this, and I cited in the brief the Jones v. US case where the courts said that a summary judgment hearing that precedes a bench trial, the judge has to ask or can ask himself, would the evidence that I'm presented with in the summary judgment hearing, if it were the same at a plenary hearing, is my judgment going to be different? And if the answer is no, they say, grant the summary judgment. That's the purpose of the rule. Get rid of the case. So this, I think, is a case that is purely based on discretion of the trial court. I mean, there are many decisions out of the district courts of appeal in the state on removal of personal representatives, failure to appoint, and they all come down to it's a discretionary decision. And the Montrello case, as counsel has mentioned, that it's very limited discretion not to appoint that person. And if that person, as the judge said in this case, doesn't do the job, you can remove them. And they said in their brief, there's very little to be done in this estate except distribute it. And there are issues which I think are probably not discussed in the briefs, but are evident from the record on appeal, that are pending.
Well, if they're not discussed, don't tell me. I
I'm not-
appreciate it.
I mean.
I got enough to worry about in the future.
I
I
can tell
wanna
you what
start
to
now.
read, but,
All right.
I think, you know, in conclusion, Your Honor, I would say that you're probably right that this didn't need to be a summary judgment case. It's presented with the same evidence.
Well, it was more of a curiosity question. If you had the answer, fine. I don't mean to stoke an argument.
Well,
Or
it's,
strategy.
I think it was really the easiest and most direct way to do this.
I'm with you.
It's,
It's a smart move.
So I think we're, unless you have further questions, I
No.
don't really have anything else to.
No, thank you very much, Mr. Spivey.
Please.
I'll save you 5 minutes. I'm doing that.
Thank you, Your Honor. I'd like to pick up right where that left off, because I want to go back to this issue of summary judgment.
It's a good
versus-
segue, isn't it?
It's a perfect segue. It may have been a good tactical decision. I've never done it that way, because I didn't think you could get a discretionary ruling from the court on summary judgment in an adversary proceeding. If there had been no summary judgment, we would go to trial. We would put evidence on,
Well,
we would notice.
you could still appeal the appointment.
We could, but
I mean,
then,
that's what you're doing
then
today.
we would be subject to an abuse of discretion standard.
Right.
If we had gone to trial,
And you're saying they procedurally didn't comply with what's
Procedurally.
required under the new rule.
even up, and I think under the old rule, it's even more clear that we would not be here, or that we should not be here on a summary judgment. The fact that the judge exercised the discretion at the summary judgment level in an adversary proceeding that otherwise would have been decided on the evidence.
How does it hurt you? How is your case hurt if the judge was wrong in denying the summary judgment versus if the judge was wrong in denying in making the appointment of the son as a personal representative? If you weren't going to appeal that appointment, you're going to go to trial on the merits. So,
It's the standard that's different.
do you even get a trial on an appointment of a PR? Is there even a trial available on that?
Yes, because the petition for administration, which becomes the pleading, it becomes the complaint in an adversary proceeding. Once you declare a petition to the adversary, that's your complaint. Now the civil rules apply. It has to have an answer and defenses raised. All of the deadlines and procedures under the civil rule apply, including your right to use evidence, your right to default, your right to use summary judgment, and your right to go to trial, which you can only do after you do a notice, after the case is at issue, and you do a notice that the case is at issue and ready to be set for trial. In an adversary proceeding, and I guess this is what I want the court to understand or acknowledge, I don't think you can skip the evidentiary trial on the appointment of a personal representative when the petition for administration has been declared an adversary. The petition for administration is the operative pleading that seeks the appointment of a
Well,
PR.
let me ask you a question. So this judge appoints the son as a PR, you vehemently disagree, he's not qualified, he's litigious, et cetera, et cetera. Then the judge says, you know what, I'll let him hear his own objection on his own accounting. Now we have an abuse of discretion. But it sounds like this judge will hold for another day if you have a true conflict, whether to appoint a third party intermediary or an ad litem to hear those objections. He didn't do it up front. So you're not really appealing that.
What we're appealing is that the court appointed a PR in an adversary proceeding on summary judgment. He exercised discretion without a trial. And the parties didn't get to go to trial after having put evidence in the record of unforeseen circumstances that occurred over a decade-long period of time where the testator could not have changed the person that he nominated because he was dead.
You're down to 1.5 minutes, just so you know.
Thank you. So I think that's an important first part is the standard here, I don't believe, is abuse of discretion. If we had had a trial and the judge then appointed the PR, it would be abuse of discretion. I want to segue from that into the Jones case, which is the federal case that was referenced. I don't think counsel articulated exactly what the case said. What I understood when I read Jones and the cases that cite to it and from it is that when it's a bench trial and not a jury trial under the federal standard, the judge is given more leeway to draw inferences. But all of the case law that I read said that doesn't mean that the judge gets to judge character or credibility at the summary judgment level. That's still done at trial. And I'll close on going back to Contrello. There are two ways that evidence can be put in that gets us past summary judgment on this case. One is that unanticipated circumstances, which I keep belaboring the decade-long period. The other one is the suitability, the character and fitness of the person, and the adverse interests. In the Pontrello case itself, the trial court ruled, there was no evidence of bad character, and there was no evidence of an adverse interest. But there was some hostility, and it would have been more efficient to appoint the non-nominated person because they were the guardian of the deceit. I'm sorry, a different case. They had more knowledge of the assets of the deceit. And for those reasons, veered away from the nominated person in the will. And the Pontrello.
We're out of time, but you want to wrap up in 20 seconds, I'll allow you to.
Sure. This court said that's not enough. The hostility alone and the efficiency, that doesn't do it. But if you have one of these exceptional circumstances, participating in the murder would be one, but it's not the only one. If you've got other circumstances where the testator couldn't change his mind, then you get there. And I think we've checked those boxes to get past summary judgment.
All right, I want to thank you both for coming. Safe journeys back home. Have a great week.
All rise.